Call on Government Order of the Day number 2. Sorry, 2 to 6.
Films, Videos and Publications Classification Objectionable Publications Amendment Bill, third reading. Customs and Excise Objectionable Publications Amendment Bill, third reading. Crimes and Indecency Amendment Bill, third reading. Accident Compensation Cover for Mental Injury Indecency Offences Amendment Bill, third reading. Vulnerable Children, Children's Worker Safety Checking Indecency Offence Amendment Bill, third reading.
Mr. Speaker.
The Honourable Amy Adams.
Mr. Speaker, I move that the bills divided from the Objectionable Publications and Indecency Legislation Bill be now read a third time. Mr. Speaker, this bill addresses an appalling issue that confronts societies around the globe. The creation and dissemination of objectionable material is a revolting scourge in our society. It's an evil that abuses and re-victimises some of the most innocent and vulnerable amongst us. Advances in technology mean that offenders can now access almost infinite quantities of objectionable material with ease. While for the most part the ability to access and share information online is a positive thing, it also enables child exploitation material offenders to view, store and share images depicting the sexual abuse of children in numbers and at speeds inconceivable even just a decade ago. In 2009, the United Nations estimated that internationally 200 new images are put into circulation every day, and the FBI has estimated that there are more than 500,000 pedophiles online at any time. There is also evidence that the content of publications is getting worse and the children involved getting younger. When offenders store and distribute this material, it fuels a market, encouraging those who create the material to produce more of it, which in turn results in more children being abused. This is a cycle we are aiming to disrupt by increasing the penalties for possession, production and distribution of child exploitation material. Once an image exists, it can be distributed to a wide audience at the click of a button. These images are being replicated and distributed further with ease, enduring long beyond the life of the victim. The bill sends a clear message that this is a repugnant a series of conduct that encourages the abuse of children, for which New Zealand has zero tolerance. I have great confidence in New Zealand's law enforcement agencies, which have a history of successful prosecutions against the scum who trade, make or possess child exploitation material. However, the law in this area is outdated and no longer reflects the ease with which offenders can obtain and share these images. Furthermore, social networking sites, online chat programs and other communications tools such as text and picture messaging have made it easier for adults to communicate with children. The bill seeks to address this increased connectivity by criminalising indecent communications with children and ensuring that those who possess or trade in child exploitation material receive a sentence that reflects the very grave nature of the offending. To achieve that purpose, the bill makes several core changes. Firstly, it increases the maximum penalties for possession, importation and export of an objectionable publication from 5 to 10 years imprisonment. The maximum penalty for supply, distribution and the making of objectionable publications increases from 10 to 14 years imprisonment. These increased penalties better reflect the seriousness of this offending and the ease with which offenders can obtain and share these images. While the bill will increase penalties for all objectionable publication offences, the extent to which a publication exploits children will continue to be an aggravating factor that the courts must take into account at sentencing. Possessing and trading in images depicting the sexual exploitation of children is grave offending that, in my view, warrants stronger penalties than other types of objectionable publications. This is why the bill also provides for a presumption of imprisonment for persons convicted of offences involving child exploitation material for a second or subsequent time. This presumption will apply unless the court is satisfied that the offender should not be so sentenced, having regard to the particular circumstances of the offender or the offence. A further technical amendment introduced by way of SOP at committee stage to the bill will ensure that the presumption of imprisonment for child exploitation material offenders applies only when a person has both committed and been convicted of a previous offence, which reflects the current situation under common law. Several factors suggest that the prospect of a prison sentence could be a strong deterrent for such offenders. While there are low rates of recidivism amongst those who trade in child exploitation material, investigations show that those who do reoffend often do so with a higher level of premeditation and go to great lengths to avoid detection through the use of sophisticated encryption, passphrases and coded communications, and law enforcement agencies have indicated that are the most desperate to avoid prison. The new sentencing regime better reflects the range of offending in this area, and both the increased penalties and presumption of imprisonment for repeat offenders will provide the court with a broader range of penalties that it can tailor to the seriousness of the offending. The bill also addresses changes in technology by clarifying that the possession of objectionable electronic publication includes intentionally viewing the material without consciously downloading or saving it. The amendment simply affirms in legislation the approach already taken by the courts and ensures that offenders with particular technical expertise are not able to escape liability by viewing electronic objectionable publications without also saving them. Lastly, Mr. Speaker, the bill creates a new Crimes Act offence of indecent communication with a young person. The new offence will apply whenever anyone over the age of 16 indecently communicates with someone under 16. The offence addresses a gap in the law that exists between objectionable publications offences, which require a record of the communication, and the sexual grooming offence, which only applies when the offender takes steps to physically meet with the young person. As with sexual grooming, the new offence will also apply where the person charged communicates indecently with a police constable, believing that police constable to be a young person. The new offence will be punishable by a maximum of 3 years imprisonment. Advances in technology mean that offenders with exploitative intent can now communicate with children with ease. These indecent communications with young people can occur in a variety of old and new media, including text, picture messaging, internet chat and telephone, and a specific offence is needed to ensure that this damaging behaviour is criminalised regardless of how it occurs. At the Committee of the Whole stage, I introduced an SOP to the bill which makes further amendments. The first amends the Accident Compensation Act to ensure that cover is provided for mental injury caused by the new offence of indecent communication and the existing sexual grooming offence in the Crimes Act. In addition, the bill now amends the Vulnerable Children's Act to ensure that anyone convicted of indecent communication with a young person will have restrictions placed on their employment in core children's workforce roles. A final amendment, Mr. Speaker, addresses a gap in the law to ensure that New Zealanders who assist foreigners to commit sexual acts against children overseas can be held liable as parties or accessories to the offence under New Zealand law. This will ensure that there are no inconsistencies between the culpability of New Zealanders that assist other New Zealanders to commit certain crimes overseas and New Zealanders that assist foreigners to commit that same type of offence. The measures in this bill send a clear message that possession of and trade in child exploitation material are abhorrent acts that encourage the abuse of children, and that indecently communicating with children is serious conduct prohibited by law. Mr. Speaker, can I note that I've welcomed the bipartisanship the House has displayed in supporting this bill, and I commend it to the House.
I call Claire Curran.